I am here with Cleveland Lawrence III. Cleveland is the co-chair of the whistleblower practice at Mehri Skalet, and we are here with him to talk about his panel at this year's Qui Tam conference, the Federal Bar's Qui Tam Section Annual Conference on February 27th and 28th of 2020. Cleve, tell us a little bit about your panel.
Yeah, sure, Scott. We are going to be focusing on emerging trends in False Claims Act litigation. So trying to kind of put our finger on the pulse of, what's going to be coming down the pike and preparing everyone, both the government and especially whistleblowers for, the types of cases that we expect.
So give me an example of maybe an emerging trend we might hear about during your panel.
So we've started to see the beginnings of more cases involving antitrust violations and bid rigging and collusive price fixing and things like that as a basis for False Claims Act liability. And
why is that a false claim?
Well, it depends on what kind of certifications are required to be made to the government. Certainly in the context of like a bid rigging or some kind of collusive pricing where the government is being victimized, that would seem to be a relatively straightforward, false claim on the government's funds. Certainly, had the government known that the prices were not proper, it would not have wanted to pay those claims. So
the government wouldn't come in, really wouldn't want to accept the claim from the very beginning.
Absolutely. So that's the theory.
So, in those kind of cases under the False Claims Act, how do damages work for a case where there might be price fixing or bid rigging from the very start?
Well, I think the most aggressive, and certainly the theory that I enjoy the most, is sort of a fraudulent inducement theory of liability, where the theory would be that the entirety of the contract is null and void because the government just never would have entered into that agreement had it known that the bid was rigged or something like that. In those types of cases, the government has even argued that the entire value of the contract then can be the measure of damages, because not only was the actual money wasted, but the purpose of the government's process was frustrated in some way, that someone was claiming eligibility for something that they should never have been eligible for.
Give me another maybe emerging trend that maybe is off the beaten path, that if I'm in the audience I might hear about.
Sure. Another trend that I think we are going to see more and more of, especially in today's world of kind of trade war, will be kind of an extension of government procurement cases that were largely based on falsifications of things like country of origin or violations of the Trade Agreements Act or the Buy America Act. We've seen kind of the uprising of those sentiments with this administration, and so all of these massive tariffs that are being placed on goods being imported into the country, some of those prices will be passed along to consumers, but a lot of companies will try to find ways around those tariffs and avoid having them collected by the government, and so those are going to be False Claims Act cases coming down the pike. Especially in the area, I think, of cybersecurity as well. And we've seen some examples of some cases, kind of on the edges of False Claims Act involving cybersecurity, especially, with the trade war and kind of the hypersensitivity about software and where it comes from and what kind of access it gives, potential hackers or others to cybersecurity, I think, is really on everyone's mind.
So in those cases, the government contractor, is making representations to the United States about its own cybersecurity? Is that what's going on?
Or about products that it's providing to the government to keep our information safe, and the origins of those goods or software or things of that nature. Certainly if we knew that software was coming from China, we would probably feel different about whether we should buy it or not.
Tell us a little bit about your panelists. Who's going to be on the panel?
Sure, I have a great group. On the Relators Bar side, we have Eric Havian, who is a partner at Constantine Cannon, a long-time Qui Tam attorney, and he's going to, I think, explore some of those antitrust issues and some of the other types of cases that are a little more novel that he and the partners at his firm are bringing. We also have John McKnight, who is a leader at the Sanford Heisler Sharp firm, and he has a lot of experience in the government procurement realm and can talk a lot about some of those Trade Agreements Act and Buy America Act frauds that we discussed a little bit. On the defense side, we have Marcia Madsen, who's one of the most knowledgeable defense lawyers in government contracting and certainly in the FCA and Qui Tam world, and a frequent speaker on panels like these. So we're expecting to add a government representative to the panel as well, but I think we're off to a really great start.
Cleve, thank you.
Great to be with you, Scott. Thanks.
And we look forward to seeing each of you on February 27th and 28th of 2020. You can register on the Federal Bar website at fedbar.org.